The Fourth Amendment. A lot of people have heard of it. A lot of people don't know what it means, though. And it's probably, as an attorney, the most common area of law that I am questioned about. Most people want to know what their rights are, and particularly what their rights against government intrusion or police interference in their lives are. Now, the Fourth Amendment, which prescribes the rule against unreasonable searches and seizures, is found in the Bill of Rights, which is the first 10 amendments to the United States Constitution. And the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now, the courts have interpreted this to mean that a search occurs when a person's subjective expectation of privacy, an expectation that society is prepared to consider reasonable, is infringed. A seizure of property occurs when there is some meaningful interference with an individual's possessory interest in that property, and a seizure of a person occurs when, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave, and when the officer, by means of physical force or show of authority, has in some way restrained the liberty of that person. Now, what is the Fourth Amendment, and when does it apply? Well, the Fourth Amendment applies only when the search or seizure is the product of government action and the search or seizure violates an individual's reasonable expectation of privacy. Now, it's important that government agents, including the police, they're government agents, that they comply with the procedures of the Fourth Amendment. And the reason is because if they don't, then the exclusionary rule applies. And the exclusionary rule applies when we have a government agent who violates the prescriptions of the Fourth Amendment. Now, to understand what a government agent or government action is, we have to understand what government action isn't. And government action isn't a private actor who searches my property and turns something into police. So if my neighbor breaks into my car and finds something illegal and turns it into the police, guess what? Although that person broke into my car and may face criminal liability themselves, the evidence that they found could still be used against me at my trial. Now, if that person acted under the direction of a government agent, like the police told them to break into my car and find stuff, then it will be considered government action. And in that particular circumstance, they will be required to comply with the prescriptions of the Fourth Amendment. Now, once we have determined that some government actor has intruded in a particular place and found evidence or searched a particular place, we have to determine whether or not it's actually a search under the Fourth Amendment to begin with. And courts have held that for it to be a search under the Fourth Amendment, the government agent must have intruded into an area where the person had a subjective expectation of privacy, and that expectation was something that society was willing to deem as reasonable. So there's both a subjective and an objective standard. As for the subjective standard, if I have a backpack and police are chasing after me and I throw it down and run away and police search that backpack when they find it, I can't argue that I had a subjective expectation of privacy because I abandoned the backpack, right? Anybody could have looked into that. However, if the backpack's still on me, well, then I had a subjective expectation of privacy as long as the backpack is zipped up. And is that something that society is willing to deem as reasonable? Sure. Society doesn't expect people to go through a zipped up backpack of theirs that's in their possession. However, we have to ask that, are there certain things that society is not willing to deem as reasonable, such as items in plain sight, or records that I give to a private institution, such as a bank, or such things that are constantly exposed to the public, such as my voice and my handwriting. Those are things that society wouldn't be willing to deem as reasonable, and as such, it wouldn't constitute a search, so we don't have to comply with the prescriptions of the Fourth Amendment and the warrant requirements. Okay, we have government action and we have a search. Now what? Well, the general rule is a search is illegal if it's not supported by a facially valid warrant or execution of the warrant is improper. And a warrantless search is per se unreasonable unless it satisfies one of the specific delineated exceptions, which I'm about to discuss. Now, to be valid, the warrant must be issued by a neutral and detached judicial officer. It must contain probable cause supported by an oath or affirmation, and it must state with particularity the place to be searched or the items or people to be seized. Now, what is probable cause to search? Probable cause to search is whether, given all of the circumstances, there's a fair probability that illegal contraband, evidence, or an individual will be found in the area to be searched. That's probable cause. So once we have that and we have a valid warrant that has been executed and issued, then we're okay. Now, what if the search was done without a warrant? Well, it's per se illegal. However, there's generally 6 exceptions that the courts have deemed to the Fourth Amendment are reasonable, so long as these exceptions are followed. And the first exception is consent. If an individual provides consent and the officer reasonably believes that that individual has authority to give consent to search that area, no warrants required. But the consent must be given by a person who officers reasonably believe can give consent, and that consent must be voluntarily given. Now, the second area, or the second exception, is what's called a search incident to a lawful arrest. And this exception applies when, number one, police lawfully arrest someone. So the arrest itself has to be supported by probable cause. Police must have enough information which allows them to reasonably believe that that person committed a criminal offense. Once that's present, then the officers are allowed to perform a limited search of the person and the immediate surroundings, their wingspan, for the purpose of locating dangerous weapons that the defendant may have or for protecting evidence that may be destroyed. The third exception is what's known as the Plainview Exception. The issue here is that the law enforcement officer must first be legitimately and legally in the location whereby the evidence can plainly be viewed, and the incriminating character of the evidence is immediately apparent. Okay? And what that means is the officers have a legal authority to be in that place, whether you consented to them entering your apartment or house, or whether you're in a public place. And it must be obvious that this is something that's illegal. An example of that is if you have a stolen stereo and the officers can see the serial number on it. Well, is the serial number itself immediately apparent that it's incriminating? And the courts have held that it's not. So it has to be something that's immediately apparent for the Plainview exception to apply. Now, the fourth exception is what's called stop and frisk. Law enforcement's permitted to stop a suspect for a short period of time, providing they have a reasonable and articulable suspicion that a criminal act is afoot. And a reasonable and articulable suspicion is more than just a mere hunch, but it's less than probable cause to arrest. And what they can do is they can perform a search. They can stop you for a reasonable period of time, and they can frisk. They can put their hands and keep their hands straight on the outside and go around your body to check to make sure that you don't have any sorts of weapons. Now, if what's called the plain feel doctrine, if they feel something while their hands are not clenched, while their hands are straight and they're frisking you, that is immediately apparent that it's something that may particularly be illegal, such as a gun or maybe a bag of drugs, well, then their suspicions are heightened, and then they may go and seize that item if it is illegal contraband. So it rises essentially to the level of plain view, but it's called the plain feel doctrine. Then we have what's called the automobile exception. Now, the automobile exception was born out of the concern that because vehicles are highly mobile, evidence could be essentially destroyed or spoiled if the vehicle travels before the warrant is obtained. The first thing that officers must have is probable cause here. Now, once they have probable cause, they can then search under the automobile exception within the passenger compartment of the vehicle. The only limitation of this exception is that law enforcement may only search those areas where the type of evidence that they're looking for can be found. Meaning, if they're looking for a machine gun, then they shouldn't be searching in the glove box or in the armrest. Otherwise, the search will be deemed invalid. And finally, we have what's called hot pursuit or exigent circumstances. Now, hot pursuit is essentially if officers they're chasing after a suspect and that suspect enters private property when being pursued, then the officers aren't required to just stop at the door and wait to obtain a warrant before entering the property, even if the suspect is in no way connected to the property in any reason. That means that as soon as that suspect enters the property, the officers can chase after that suspect into the property. And exigent circumstances are essentially when evidence can easily be moved, destroyed, or otherwise made to disappear before a warrant can be issued. Then the evidence or individual may be seized without a warrant. And also it means that when an emergency circumstance arises, such as a life-threatening event, then the law enforcement officer is permitted to forcibly enter a property without a search warrant. And obviously, once that officer does that, if there are items that are in plain view, the officer's there lawfully, and the officer can seize those items, and those items will be admissible at trial. So there you go. That's the Fourth Amendment, and that's exactly what the officers have to follow, the rules they have to follow when a search takes place, and the exceptions that allow them to search without a valid warrant. So, what do you have to do? Number one, don't do illegal things. But number two, know your rights and exercise your rights.